Hello, everybody. Hello. So I'd like to get this afternoon's program going and want to thank you for joining us. I'm Caroline Fredrickson. I'm the president of the American Constitution Society. Before we go into the panel, I do want to thank EPI for allowing us to use this wonderful space. I think you're all probably familiar with ACS, but if there's anyone in this audience who is not, well, shame on you. You should know that ACS is an organization that was founded in 2001, and we are a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. And ACS works for positive change by shaping the debate on the vitally important legal and constitutional issues that face us, such as the ones that we will discuss today. So as this audience is painfully aware, Senate Republicans spent 9.5 months refusing to consider President Obama's nominee to fill the vacancy on the Supreme Court. And that was the D.C. Circuit Chief Judge Merrick Garland. That unprecedented obstruction brings us to this moment in time. Now, just a little more than 3 weeks after President Trump's nomination of 10th Circuit Judge Neil Gorsuch to the same seat, we now have heard that hearings will begin on March 20th. So, of course, there are many questions for all of us to consider. For example, what have been the major themes of Judge Gorsuch's writings and jurisprudence, and how do they reflect his vision of the law? Are his views within the mainstream, and how would his confirmation affect the Supreme Court institutionally and jurisprudentially? Perhaps most critically, how does Gorsuch understand the role of the judiciary in relationship to the other branches of government? To lead today's discussion with our very distinguished panel, we have an expert on the Supreme Court. Until very recently, Amy Howe served as the editor of the SCOTUS blog, a blog that this audience reads on a daily basis and maybe even more often than that. Amy continues to serve as a reporter for SCOTUS blog and also writes for her eponymous blog, Howe on the Court. She's served as counsel in over 24 merits cases at the Supreme Court and argued 2 cases there. She also co-taught Supreme Court litigation at both Stanford and Harvard law schools, and therefore comes to us as probably the most perfect person who we could have to moderate today's discussion. So please join me in welcoming Amy Howe.
Caroline, it has been a little over a year since Justice Scalia's death, and a little over 3 weeks since President Trump nominated Neil Gorsuch to fill the vacancy left by Justice Scalia's death. You have probably now seen the commercials with Judge Gorsuch's former clerks, who, not surprisingly, think he would be terrific on the Supreme Court. You may have seen, hopefully, the pictures of Judge Gorsuch playing with the puppies when he goes to visit senators for the courtesy visits. But we are here to take a deeper dive into Judge Gorsuch and what his impact might be on the court. And we have 3 experts here to help us with that in alphabetical order, but starting also on my far left. We have Christopher Kang, who's the National Director of the National Council of Asian Pacific Americans. Chris spent 6 years in the Obama White House, where, among other things, he spearheaded the legislative outreach and strategy for the confirmations of Justices Sonia Sotomayor and Elena Kagan. So he's going to help guide us through the process. Next to him, we have Louise Melling, who's the Deputy Legal Director of the ACLU and the Director of its Center for Liberty, whose portfolio includes reproductive rights, women's rights, LGBT rights, and religious freedom. And then next to me, we have Matt Wessler, who's a partner in the law firm Gupta Wessler and is an expert on Supreme Court litigation, and in particular areas like ERISA, preemption, arbitration, and healthcare. We're going to leave about 30 minutes for your questions, and I'm going to start with Louise and Judge Gorsuch's views on personal liberty, abortion, right to die, LGBT, and contraception. Tell us a little bit about the major themes in his writing and what they tell us.
Can you hear me? Is that driving on? Okay. So thank you so much. Thank you for inviting me. So on some of the topics, I think you probably all know from reading the press, on some of these topics, Gorsuch hasn't said that much. So, for example, I think the number one question people often ask me is, what does Gorsuch have to say about abortion? And he has no decision squarely on topic. There's some phrases and some discussion of the Planned Parenthood versus Casey decision, the 1992 decision of the Supreme Court, which reaffirmed Roe, albeit changed the test and therefore diminished Roe, where he is, I would just say, very, very careful in terms of how he discusses it and reads it quite narrowly in terms of treating it more as a case about stare decisis than as about substantive due process or its equality. But so there are two things that I think are sort of more interesting in some sense based on what he has said. So one, and I'm going to draw part of this from that two-page piece in the National Review about liberalism and lawsuits, where he opines about how liberals are sort of, I'll just call it mistakenly, that's not his word, resorting to the courts continuously to assert a progressive agenda, and how that doesn't serve us and how that also undermines the court in terms of the courts then being seen as political and illegitimate. That piece, I think, tells you a fair amount when you read it about his view about whether the courts should have expansive roles or whether he thinks, as he articulates in that piece, that more decisions should be made in the legislatures, including in state legislatures. I think it tells you something about his view a little bit about majoritarianism and anti-majoritarianism. I'm in this business in part because I think the legislatures don't always protect people. We can just think about how many years would it have taken before all 50 states would have come through their legislative process to recognize the right for same-sex Americans. How many years would it take us before we could get congressional action or we could get state legislatures to recognize the rights of transgender people? What would the country look like if we had to rely on state legislatures purely and exclusively for purposes of abortion rights? So I think that's telling. Also note that he talks about the use of the courts only by liberals, as evidenced by the title. And we can think about the challenges to the contraception rule. We can think about the about the modifications and arguments about what the Second Amendment means as the use of courts on, sort of the other side, so to speak. The courts are used, not used. The courts it's a legitimate process. I don't mean use in that way, but the courts are a vehicle for us to assert rights in different dimensions. The thing that I find sort of most interesting, or just want to flag for you, is how he's thinking about religion. How he's thinking about religion in terms of free exercise, how he's thinking about it in terms of establishment, and then what that has to say about the Constitution, about what society looks like, and about the progress of equality. And I'm going to point to his decisions in the contraception cases. He joined the majority in Hobby Lobby. Hobby Lobby, the 10th Circuit was the court that found a RFRA violation when Hobby Lobby argued it would violate their religious rights under the statute to provide coverage for their employees through the insurance for contraceptive coverage. And some people say, well, Melling, how can you complain? Like the Supreme Court, upheld that. There's a few things that are really sort of different and worth noting. So the most significant is that in Hobby Lobby in the 10th Circuit, when it looked at the case, talked quite compellingly about the harms to the business as well as to the owners. But then when it looked at the other side, when it looked at the cost were Hobby Lobby not to comply, it said there'll be an economic burden for women. And that economic burden did not in any way stop the court from reaching its result. And, in the language of sort of Fred Geddix, who's a professor at Brigham Young, one of the questions about what religious liberty means is, does it mean that you have to pay for somebody else's religion? Hobby Lobby, as decided by the 10th Circuit, said that employees had to pay for their employer's religion. The Supreme Court was different in how it analyzed the case, in that the Supreme Court, when it looked at the statute, it said, yes, the company's burdened. It got to the side of compelling state interest, least restrictive means. And yeah, sorry, I'm assuming everybody's a lawyer and talking about these things. Said, well, there's another option. the government could extend its accommodation. This was an accommodation for nonprofit entities, could extend its accommodation to entities like Hobby Lobby. The accommodation, we can all dispute what we, how we think it works and whether it was a right call, but the accommodation was intended to say, to work such that the employer could step away by signing a form and saying, I don't want to comply, and then the insurance company would pick up the coverage and provide it seamlessly to women. The majority opinion says, if the government does that, there will be zero effect on women employees. You see a similar strain in the Supreme Court's decision when it addresses the accommodation in terms of caring about the harm to the other side if you accommodate religion. I have more things I can say about the Hobby Lobby, but I'll sort of leave it at that for purposes of Hobby Lobby. But Gorsuch has shown himself to be very attentive to free exercise claims, including claims of prisoners of different religions, very attentive in the context of Hobby Lobby, not as attentive in that case to harms, and then in the context of the Establishment Clause, has dissented in terms of believing that it is not an endorsement of religion, it's not a violation of the Establishment Clause for different kinds of displays of crosses and of the Ten Commandments, displays that the other courts have sort of rejected as a violation of the Establishment Clause. So you put together a sort of hands-off in terms of the government not seeing things as establishment, and then a robust understanding of free exercise. And I think you can imagine a very different place for religion in society if he's on the bench and has a deciding vote.
And I guess that's actually the question. I mean, I think a lot of people tend to think of this battle as important, but there's a sense that he's replacing Justice Scalia, who was a conservative, and that the real battle is going to be the next one if Justice Anthony Kennedy or Judge Ruth Bader Ginsburg retires. So do you think that in some sense that even replacing, on these issues, replacing Scalia with Gorsuch would sort of shift the court's jurisprudence?
I like to tell myself that story, that it won't get worse, that it's a replacement for Scalia. And then I'm interested in what other people have to say to that, because I think sometimes it's personality in terms of whether you can win people over in a close case. And Scalia was described to me as charming, but not necessarily somebody who brought other members of the court along, given his particular philosophy and manner in times. And then on these close questions coming, I don't think they're close, but I think the court will think they're close. For example, should the court take a case like Arlene's Flowers or Masterpiece? I don't know what they're going to think of that.
And those are cases involving...
Thank you.
Yes.
You don't all have to live in my head. I'm so sorry for thinking you're there. Those are cases involving businesses. In the case of Arlene's Flowers, a florist. In the case of Masterpiece Cake Shop, a bakery, that turned away same-sex couples when they wanted flowers or a cake for their wedding. The florist and the bakery would provide those services to heterosexual couples, but not to same-sex couples, because of the owner's beliefs that violated their view that marriage was for a man and woman. In both of those cases, the state courts rejected a claim that requiring the businesses to comply with anti-discrimination laws violated their religious freedom or speech and association. And Masterpiece is now before the court, fully briefed petition. It's coming up again for a possible decision on whether they'll hear it or not on Monday. Arlene's Flowers was just decided by the Washington State Supreme Court within the last 2 weeks. I think Alliance Defending Freedom is representing Arlene in that case and has said they will petition for cert.
And the Supreme Court had a similar petition out of New Mexico involving someone who didn't want to photograph a same-sex marriage ceremony, and they turned it down.
Yes.
And that was before Justice Scalia died, I believe.
I think that's, yes.
Okay.
I think.
Yeah, so it will be interesting to see, if this first petition is up this week, what the court does with it, knowing that Gorsuch, could be on the horizon. There was a case involving a church in Missouri that, and whether or not it violated the Constitution. It was the church's argument for the state to deny it a grant to resurface its playground on the ground that it was a church. And the Supreme Court granted review in this case in January of 2016, before Justice Scalia died, and then the case sort of disappeared from the court's docket. It had been fully briefed, and every time an argument calendar came out, we waited and we waited, and finally this past week they scheduled it for oral argument in April. So not only a day or two after they scheduled the confirmation hearings. Coincidence. And so I think we'll move on. If you were advising a senator and you wanted to ask Judge Gorsuch questions at the confirmation hearings or on these issues, are there any in particular you'd ask?
Well, I'd certainly want to be asking the judge about his views about abortion, but I would want to ask, and I just sort of assume we were all operating on the premise that President Trump has said that he will appoint justices who are pro-life, and it was clear from his interview that meant he was content, I'll say, with having Roe overruled in terms of being relatively dismissive when Leslie Stahl said, well, won't that mean that there will be some women who can't get abortions? And he just said, well, they can go to another state should their state ban it. So I would want to ask about abortion, but I think there's a question that goes beyond what his views are of Roe versus Wade or Planned Parenthood versus Casey. I'd want to be asking him what he also thinks about whole women's health, which is the decision from this summer. And in that decision, the court gave the test articulated in Casey teeth. The court gave that test more meaning in terms of saying that the state was held to a burden, at least to show that its regulation served health interests, if that's what they asserted. So it added another dimension for when we go and challenge restrictions on abortion in terms of establishing them as unconstitutional. Those questions about chipping away and what it means, those have been the questions that have really been pivotal in terms of whether or not women have access to abortion and, therefore, greater prospects for our equality. I'd want to know about that. That's related to questions about precedent. I'd want to ask him about religious liberty, and I'd want to ask him, how he understands religious liberty in terms of whether it comes with the right to impose your views on others or harm others, and what are the limits in that context. In the context of the 10th Circuit decision addressing the contraceptive rule, and in particular the accommodation being the rule that said if you objected, you could fill out a form, notify the government that you objected, notify your insurer that you objected, and then the insurer would pick up the rule. Judge Gorsuch was, I think, in many ways very understanding about how the owners of the company understood that to violate their faith. But he talks about complicity and how your view that you will be complicit in a crime or complicit in a sin in a very broad way. And I think it just raises a serious question in terms of where are the limits. And I think this is a serious question I think any of us who think about this question about religious liberty have to tangle with. What are the limits in terms of what constitutes a substantial burden? Like, is there meaning to the word substantial? And if so, what? And then how far away does everything that counts as complicity sort of count? Is it sort of all the same for purposes of understanding a claim of free exercise under the Religious Freedom Restoration Act? And so when I think about that, I think about you can object to the death penalty, and you are then complicit when you pay taxes. You might be complicit when you drive somebody to the prison. You might be complicit when you sign somebody in. You're complicit when you strap somebody down, and you're the actor when you inject. And should we treat those differently? And if not, what does it mean if we don't draw those lines? And I'll say I'm not the person who knows where you draw the lines. Please don't. Just to put that question off. But I think that's an important question to ask, because it's important, I think, that we have boundaries as we think about exemptions from laws that otherwise apply.
All right, one last question for you, then we'll move on. Judge Gorsuch has not written on abortion. As you said, he has written at length about assisted suicide and euthanasia. I have his book, sitting on my desk. I need to read it. Is there anything that you know about his views that might give us some hint about how he might react to an abortion case?
Well, I'll just say, first of all, the sales of his book, I think, are doing very well subsequent to his nomination.
I ordered it the night he was confirmed, and then I think it sold out. So,
Well, yes,
yeah.
it was when I went on, the hardcover was $90, and it was unavailable. And the
Apparently
Kindle,
the proceeds are going to hospice care, so if
Really?
that
That's
makes you,
interesting.
but although maybe not on
the
Amazon.
Kindle version was $26, which, so I cannot profess to having read the whole book. I have skimmed portions of the
It's
book.
it's long.
So he has a theory about the inviolability of life and the common good in human life. And in the book he's very careful to not genuinely engage with what his argument would mean for abortion or what it would mean for the death penalty, for example. And he works very hard in what I've seen to draw distinctions between refusing aid that could then result, or having aid taken away, that can result in your death, versus having any kind of assistance to expedite your death. I think it certainly, he construes language in Casey that talks about, it's some of that more sweeping language, poetic language that Justice Kennedy sometimes writes in his opinions. About the meaning of life and autonomy, and he definitely works to cabin that and to say that language shouldn't have, it's more dicta than anything else, and that's where he sort of then falls back to stare decisis in terms of interpreting Casey so as to limit the implications of that language for other autonomy claims. So, not having read the whole book, just you certainly can read that as he's working hard to cabin the autonomy claim, but he's taking very seriously what the boundaries are, and some issues that I think we all have to take seriously as we think about aid in dying, in terms of, in particular, making sure that aid, like we talk about a right to aid in dying as well as a right to live, in the sense of making sure that if you recognize if the autonomy right, that you're also careful that you put in sufficient caveats to make sure that people are making the choice robustly. But we certainly would say that the Constitution lands on the other side from where Judge Gorsuch lands.
Okay, great. Thank you. I'm going to move on to Matt and some of the same questions with regard to class actions, access to justice, and regulations.
Yeah, I mean, I think at kind of the top level, and this may be true as we get further into this conversation, a lot of the comments are sort of the same, which is to say that, you know, you can look through the decisions that Judge Gorsuch has authored or dissented from on issues involving aggregate litigation, the use of mandatory arbitration, preemption, standards applying to employment discrimination cases, and it's hard to really, I think, glean some common threads that run through that in an intelligible way that could yield some clear, identifying, cohesive principle that will, you know, lead him to view a case up at the court one way or another. And part of that, you know, is a product of just the fact that he hasn't been on the bench that long comparatively. I mean, it's a decade, I guess. But in you know, if you compare that with, you know, judges who've been sitting as circuit judges for 25 or 30 years, the body of work just looks different. But I also think that he's been really, really careful, and I think that it is no pure coincidence that you don't find much in the record of judicial decision making that yields some intelligible principles about some of the really important issues that the Supreme Court has always faced and will continue to face. And so part of the job is to sort of try to canvass not just what he's written in decisions, but also work that has appeared outside of the four corners of a you know, a court of appeals opinion. And I think it's fair to say that if you fold in what he's written outside of his actual, you know, job, that he kind of holds a kind of default skepticism when it comes to questions of class actions and opening the courthouse doors for plaintiffs who are seeking relief and are seeking accountability when corporations commit wrongdoing. And part of that is I think it's been out there in the press a lot. He's written not just this one couple-page article in the National Review that I think he has said he quite regrets, but also in service of his job as a lawyer, wrote an article in a big class action case that was up at the court, this case called Dura Pharmaceuticals, and which he also authored a brief on behalf of corporate interests in that case. And he said, this was in the context of a plaintiff security class action, so a class action involving shareholders in who held shares of in a corporation and who alleged that the company had deceived them in a way that had caused them monetary harm. And he was really, really skeptical that in general these cases are meritorious cases. I think it's really quite fair to say that. He accused the plaintiffs' lawyers who represent these classes as essentially looking for a quick ride to fast riches, and asserted that in large part these cases were unmeritorious cases that were designed essentially to produce a quick settlement, a payout for the plaintiffs' lawyers, and not so much for the individuals. And look, there's a policy debate about some of these questions. That's true, I think, but I think he definitely, in that particular case, and I think more broadly, shares this kind of base level of skepticism that class actions are, on balance, value maximizing. And I think that as lawyers up here on the dais, but also for those who believe that when it comes to this question of whether there should be viable mechanisms for holding companies accountable for large and small violations of the law, aggregate litigation serves those interests, that in general we should hope that those efforts are not curtailed in large and important ways, that he probably disagrees with that. And I think that if he is up on the court, that will probably shine through in cases in which the court has to decide whether to expand or constrict either the mechanisms that are available to citizens who've been harmed by companies, or the relief that they can obtain in a lawsuit. And there's some support for that in the body of his actual work as a judge in the 10th Circuit. But you can read those opinions and not really, I think, it doesn't come through. There aren't any, robust affirmative statements casting doubt on the utility of a class action or on the value of the employment discrimination statutes, for instance. But instead, the result of his judging, I think, is a much more kind of under the radar approach that ultimately cloaks a decision affirming the denial of a plaintiff's claim. So kicking a plaintiff out of court, for instance, or hamstringing the scope or nature of a class action through a much more like procedural mechanism. And I think you can see this if I was to draw one kind of common thread, at least in a kind of, there aren't enough cases to really do this, but if you were to sort of compare a couple of the cases, there's a case that's been out there called Shook and another one called Hammond versus Stamps.com, which are two class action cases that he's decided. One commonality between the two is a kind of oscillating use of standard of review to reach the preferred result. And what I mean by that is, in one of those cases, this case Stamps.com, that case involved a question of essentially whether under CAFA, which is this federal law that provides a company with a defendant in a class action with an opportunity to take a case out of state court and move it into federal court if there's a minimum amount of money at stake in the case. He reversed a district court's denial of that company's effort to get the case out of state court and rejected a kind of deferential approach to what the district court did. So essentially he said, right, the district court abused its discretion in refusing to allow the company to take the case out of one forum and put it into another. And on the flip side of that, in this case versus Shook, which was not a CAFA case, but rather a question of whether a class could be certified under Rule 23 of the Federal Rules of Civil Procedure, the district court had denied the certification in the class and had said essentially there are too many plaintiffs with individualized issues in the case, so that allowing this case to move forward would be essentially unmanageable. And so I'm going to deny the class's effort to band together to bring one suit against this company for these small dollar violations of the law. And he, in affirming that district court's decision denying class certification, again cloaked himself in a kind of standard of review based analysis where he said, look, we really do have to defer to the district judge's view of the way this case would work out, and the facts that have been presented to the court appear, we may have, if we were looking at this afresh or anew, we might reach a different conclusion, but because we're sort of required to defer to what the lower court did in this case, will affirm the result here. And I think, you can, there are different contexts, but what you see going on there is a kind of procedural move that allows the court and Judge Gorsuch in particular to reach a preferred outcome, which is either to affirm the denial of some plaintiffs' efforts to band together and hold the company accountable on the one hand, and then on the other hand, to unravel a lower court's effort to essentially allow the plaintiffs to choose the form in which they bring a lawsuit and instead hand to the defendant corporation the advantage in litigating a case in their preferred forum. And so that's a very that is a hard thing to sort of shout out and say, hey, look at this. This is something that's really going to make a difference. But when you are a smart, careful judge that is trying to not rock the boat and not do something that would look results-oriented, this is exactly the kind of move you would make. And I think, that this is going on in the way that he approaches cases. For anybody who's really kind of doing this litigation, in these courts, that is a very common way that I think, you see, the conservative Supreme Court often using these moves as well. Conservative judges in the circuits do this. And I think that instead of shouting out, I'm really skeptical that anybody is really discriminated against, and so why should we let this company be terrorized by these plaintiffs, you kind of deploy these lower level procedural tools as a way to reach that result without saying so explicitly. I think just two more points, and then we can either move on or you can ask me some more questions. But there is he actually has written a couple of decisions that do implicate this question of forced arbitration, which, as I think probably most of us in the room know, is really become increasingly the battleground for progressive issues, at least as they're being litigated through the court. And I think, again, that although it's not something that totally jumps off the page, he tends, I think, to have, which is not very surprising, a view that on balance, the use of forced arbitration is, in fact, a value maximizing principle and has viewed the Federal Arbitration Act, which is the federal law that gives life to these arbitration clauses that are often stuck in the back of 40-page contracts. This kind of force of federal law, he has viewed that, I think, broadly. And he dissented in one case involving a question about whether a disagreement over the mechanism of arbitration should have authorized a district court to deny the use of arbitration entirely. He dissented in that case and said, I think that under the Federal Arbitration Act, the parties in the case absolutely agreed to arbitrate, and simply because you can't identify the mechanism by which you arbitrate, that's not a reason alone to refuse to enforce the agreement, and you could just come up with an alternative way to allow the arbitration to move forward. And that's a very technical question, but as anybody who's litigated in this area knows, it's actually a hotly contested one, and there's a real statutory question about what the meaning of the Federal Arbitration Act is on how essentially how active courts can be in doing something that isn't clear from the actual arbitration provision that they're confronted with. And he, in his view, would have essentially expanded the scope of Section 5 of the Federal Arbitration Act, which, if you're trying to sort of glean what his view is of this mechanism, that would be a very pro-arbitration move. And it's consistent, I think, with another one of his arbitration decisions in which he essentially affirmed a motion to compel arbitration. And so, again, that issue has been one that has occupied the Supreme Court for the last 10 years and has really been the architect of the pro-arbitration decisions that have come down from this court has been Justice Scalia. I think he really has breathed life into this very robust view of how companies can use these clauses to get themselves out of court, to hide their wrongdoing from public view, and to suppress the kinds of claims that you'd see in the absence of these clauses. And I think there's no reason to think that Judge Gorsuch would, if he were ultimately on the court, would actually be inclined to do anything other than continue that march forward down the road. I do think that the court has just recently taken a series of cases that raised an important question of arbitration involving whether the NLRB, the National Labor Relations Board, can restrict the use of class action bans in the context of employment wage and hour cases, and that case has been teed up for next term. And so, I think the court took that case and ultimately set it for argument, anticipating that there would be a full complement on the court. And I think that it's always uncertain how a case is going to unfold at the merits stage when the parties have fully briefed it. But I think there's reason to think that he would align himself much more closely with the way that the conservative bloc on the court has thought about that issue than with the progressive bloc. I haven't actually gotten into Chevron deference or regulatory issues. I do feel like that is the one area that we actually know a lot more about. Maybe we can talk about it during the question and answer period.
Okay, great. So I think to sort of follow up, you answered one of the other questions I was going to ask you, but sort of to follow up and recognizing that there has been a trend in recent confirmation hearings for nominees to not actually answer questions with any real substance on the ground that they fear that this issue may come up. But if you could ask questions, are there specific questions you would ask?
Yeah, I mean, I sort of am of the view, and this is seeding into Chris's territory.
Okay, we'll talk more about this.
But I think open-ended questions that allow the nominee to not give the nominee a chance to sort of say, well, that could come before the court, so I really can't answer. But open-ended questions that are broad-based, to me, seem like effective ways to at least try to glean some sense of where the nominee would be coming from. And so I would be, interested to know, in general, what is your view of the effectiveness of aggregate litigation? Like, do you see the value in class actions? If so, how and why? What's your take on the use of mandatory arbitration? The most robust empirical report that exists in the world to this day about the effect of arbitrations comes from the Consumer Financial Protection Bureau that had several years to do an incredibly thorough effort at trying to understand and study the use and effect of how companies use these arbitration agreements. And I would want to know if he's read that report. I'd want to know if he has read that report, what his view is of the conclusions in that report, which essentially establish that these clauses are nothing more than claim suppression tools. They just eliminate the ability of plaintiffs to file cases in court and allow companies to avoid accountability for whatever wrongdoing they may have committed. And that doesn't necessarily trample or trench on a potential case in front of the court, but it does ask a kind of broader question about his awareness of these issues and what his view is on them.
Terrific, thanks. Well, we're going to move on now from issues to Chris and process. And I want to start with the process by which President Trump identified Judge Gorsuch as a nominee. As you all know, we put out 2 lists of potential nominees, and during the campaign, and pledged to nominate one of those judges to the court. So this, it seems as almost everything Trump is doing is breaking the mold, but this was certainly not something we'd seen before.
Yeah, and so I appreciate that. It turns out it was quite unusual, the way he went about this. And I think it's important to understand sort of just why it's different and how it's different and why it's so problematic, right? So I worked in the White House counsel's office for 4.5 years, selecting and vetting and sort of shepherding through confirmation 225 of President Obama's federal judges. And in the course of that process, we certainly reached out to organizations and interest groups, bar associations, American Constitution Society, senators and others for their recommendations. And that is an important, valuable, and necessary part of the process. But where it sort of falls apart is I never went to one organization and said, you give me the only list I'm going to look at. One, I don't actually think that that's in service to the president to limit his options in that way. But two, it really goes to emphasize just how President Trump and then candidate Trump views the role of the judiciary and really how much disregard he has for the independence of the judiciary. Right? We focused a lot over the last month on this idea of this tweet of a so-called judge, and that is incredibly it's, by the way, a lot more than demoralizing in terms of the impact on the court, but it really says something about what he thinks about the judiciary. The very idea that he would outsource his entire process to two ideological interest groups and say, you pick these for me, it's not just because people think that President Trump doesn't care about the courts, he's deferring. It's really he's outsourcing this to ideological groups because he doesn't see anything wrong with that. He doesn't see anything wrong with letting ideological organizations pick the judges who are going to sit on the courts because he doesn't understand the value of an independent judiciary. Similarly, we've talked a little bit about his litmus tests and the litmus tests that he went through. There are a number of them throughout the campaign as he sort of sought to curry favor with people who might be considering voting for him or not voting for him and sort of tries to reinforce his credentials. But this idea then that he would go through and have a litmus test, and therefore we must assume that Judge Gorsuch has passed these litmus tests, in particular with respect to overturning Roe versus Wade, is another way of really undermining the independence of the judiciary. And I think we really have to see that for what it is in this bigger frame to really understand just how damaging and dangerous this has been.
All right, and so let's talk a little bit about the courtesy visits. We just see that when you're not present for them, you see the pictures on TV. Everyone looks kind of awkward, although sometimes again Gorsuch gets to play with puppies. What happens during behind the scenes in those visits, and what kind of questions are the senators asking?
So that is a good question. They're called courtesy meetings, and I think that sort of doesn't do them justice. I think that at the end of the day, these meetings are 30, 45-minute meetings on substantive issues, or should be on substantive issues of the law, on the judge's record, on how he or she views the role of a judge, the role of the Supreme Court, issues of precedent, substantive areas of law, and they really will have an opportunity to get into the back and forth. And so I accompanied Justices Sotomayor and Kagan on all of their courtesy visits, and senators, not surprisingly, all treat these differently. Some of them seek to make a personal connection to get to know the judge a little bit better. Some of them seek to raise issues of importance, either to themselves or personally, so it's a little opportunity for them to lobby. I recall one senator lobbying Justice Kagan about his views on the Commerce Clause, sort of in opposition to the Affordable Care Act. That thought was an interesting opportunity that he took. And some of them sort of do it to press on issues that they may have concerns about, issues they may have heard in the paper, issues to sort of give themselves either more comfort or possibly to confirm their concerns as they make a decision on how to vote on the nomination. So they really are substantive and in-depth and an opportunity for the nominee to make his or her best case.
And so, is it substantive going in both directions? Do the senators expect? Did the senator expect Justice Kagan to sort of talk about the Commerce Clause?
Well, not in that particular exchange, but in general, yes. And I think that part of what there's this big debate right now over how much Judge Gorsuch should be expected to say in his courtesy meetings or at the hearing. And I think Senator McConnell has even said, well, the way this goes is we ask the questions and we don't expect the answers. And that's not actually the way it should be, right? This is advice and consent, and you really need to get a sense of the judge and his or her judicial philosophy and temperament. And so, at the end of the day, though, it's a political process, and I think part of the balance depends on where you are in this process, right? So having 59 or 60 Democratic senators, I think that Justices Sotomayor and Kagan didn't have to say as much in order to give enough senators the comfort and confidence and information they needed to proceed to confirmation. In this case, Judge Gorsuch will need to convince 8 Democratic senators that he's given them enough information about his views and about his temperament. And I think that is very different. I think that if he continues to not give them the information they're seeking, and one of the things we have seen coming out of the courtesy meeting is a level of frustration among Democratic senators that he's not being forthcoming, that he's not being fulsome and substantive as they expect, or frankly, their expectations aren't as important as what their demands, right? What they need in order to hear to make a decision. I think he's going to have a very hard time being confirmed.
I want to go back to something you said earlier, talking about the president's tweet about the so-called judge. And one of the things that happened was that, after a courtesy visit, one of the senators said that Gorsuch was critical of those comments. Is it common for things to sort of leak out of the courtesy visits? And then I know that the follow-up was that the Trump White House said, well, he was just he wasn't criticizing Trump specifically, but just attacks on the judiciary.
Yeah, I think that when you go into any of these meetings, the advice we give nominees is that anything you say in the room, you should expect to be said outside of the room. And so I think there is an expectation that some of this stuff, I wouldn't say is leaking out. I think sometimes it's expected to come out. And I would argue that it seemed to be a coordinated effort that Judge Gorsuch said it to enough senators, maybe these exact same words, because he wanted it to come out. He wanted to have this space to try to distance himself from the president's attacks. I think the interesting thing that perhaps he and his team didn't anticipate was just how President Trump would try to walk that back and really tether themselves together a little bit more.
So, as Caroline said, the hearings are going to start on March 20th. Can you walk us through sort of what's going to happen during the hearings? What will they look like? And then what I think perhaps what people are most interested in, particularly given that the Supreme Court starts its final session of oral arguments in late April. Sort of what does the timeline look like after the hearings?
So the hearings are set for March 20th. I'm losing all track of time. It's been quite the month. So March 20th, the 4 days of hearings will include opening statements by all of the senators, an opening statement by Judge Gorsuch on the first day, then probably 2 days of questions in which senators will have maybe 20-minute rounds of questions. So for those folks who have been watching, for example, the Attorney General hearings and other hearings in the Senate Judiciary Committee where you feel like, boy, they got gavelled down pretty quickly. If only they had a little bit more time, maybe they could ask a little more follow-up questions, get some more answers. This will be more of that fulsome conversation and back and forth exchange. And then the fourth day will be for expert witnesses to sort of talk about their views on how Judge Gorsuch's confirmation might affect the future of the court. After that, the timeline may be a little bit compressed, but on average, the time between the start of the hearing to a floor vote is probably 3 to 4 weeks. My guess, and what I think that Chairman Grassley and others have said, is that the Senate goes on recess on April 10th. And that is probably more of a driver of when the Senate's going to vote on Judge Gorsuch's nomination than the court schedule. I think that it turns out that senators like to take recess when they get recess and don't like to be here when they have other plans. And so my anticipation is that they'll either move up that timeline to something more like 17 or 18 days, which was actually the timeline for for Justice Roberts between start of his hearing and the floor vote, and have that first vote before the April 10 recess. Or Senator McConnell could, if Democrats insist to have a little more time, he could offer to cancel the recess and sort of give Democrats a little bit more time. It's fairly unlikely that that'll happen. And then the question will be what happens at that first vote. I think that there's been a lot of conversation about cloture vote, filibuster, thresholds, and sort of what happens. In the Senate, as most or maybe all of you know, any one senator can insist on a 60-vote threshold. And I think there now are a number of senators who said that they will insist on a 60-vote threshold in order to move this nomination to a final confirmation vote. So there will be that vote at a 60-vote threshold. It's called a cloture vote to cut off debate. And right now, every single Democratic senator has said that they support that concept of a 60-vote threshold. And so the question then is how many of them will actually vote in favor of that 60-vote threshold in order to move to final confirmation. And I think it's important to realize there's a lot of talk about precedent and sort of how things have been treated. And I have two responses to that. One is I do think that the unprecedented obstruction of Chief Judge Garland's nomination sort of looms over all of this. I think for some senators, this stolen seat is in and of itself reason to oppose this nominee. I think those senators are sort of just a few, but there is that level of outrage, and I think justifiable outrage over how Chief Judge Garland was treated. But then for the rest of the caucus, there's still this sense of the pot calling the kettle black, that Senator McConnell would really have the audacity to challenge a 60-vote threshold on the floor when they didn't even give Chief Judge Garland a hearing and a committee vote. I don't think that the Democratic senators are going to have a hard time squaring that circle and saying that, of course, at least Judge Gorsuch should be held to a 60-vote threshold. I'll also note that Senate Republicans insisted on a 60-vote threshold for 11 of President Obama's judicial nominees, including a district court judge in Rhode Island. So the idea that Senate Republicans would think that a district court judge in Rhode Island should be held to a 60-vote threshold, but a Supreme Court nominee should not, again, doesn't pass the laugh test. I think that Judge Gorsuch should be held to a 60-vote threshold, and if he can't meet it, I would suggest that is a sign by Senate Democrats that President Trump should be consulting with them and not just the Heritage Foundation and Federalist Society in fulfilling their advice and consent responsibilities and picking the next Supreme Court justice.
You guys want to weigh in? Are you? No? All right, well, I think we can take your questions now. And there's going to be some handheld mics circulating around so that everyone else can hear you and so that the video can hear you. All right, we have one up here, please. Thanks.
I'm Mark Gruenberg from Press Associates Union News Service, and I'd like to ask Matthew to touch about the topic you passed over, which is Gorsuch's views on basically the Chevron deference.
Yeah, the elephant in the room, which is actually how he described it in Gutierrez. So there is this decision from last year called Gutierrez-Brizuela or something like that, and so for anybody in the room who is, and this is all very jargony, so I want to make sure that it's clear for anybody who isn't familiar with this term called Chevron. The idea behind this doctrine, this thing called Chevron deference, is that federal agencies are given the ability to step into a gap that has been left by Congress by reaching policy decisions about a particular question, and if they step into that gap and pass a rule, a regulation that clarifies an ambiguity that Congress itself has not on its own clarified, and that regulation is passed through a notice and comment period process, a rulemaking process that comports with a kind of basic threshold of procedural accountability. that courts will defer to the agency's policy decision that's contained in that rule, and will not, on their own, look back to the statute to try to resolve the ambiguity that was left in the law. And so just as an example, I'm just pulling this randomly, but if Congress had used the term pollution source in a law, and it's not clear from the text of that law or the legislative history what Congress meant to include within the scope of this term pollution source, Chevron deference, in theory, would allow an agency, the EPA, to pass a regulation that defines that term and gives it meaning. And this doctrine has been around for quite some time, and it has taken on a kind of breadth and scope, so that it is really it occupies a very large part of the kind of regulatory doctrine that exists currently today. And in this case, in 2016, Judge Gorsuch wrote an opinion that was joined by the two other members of the panel in the 10th Circuit, in which he essentially looked at an agency. In this case, it was involved the immigration laws, and the Board of Immigration Appeals, the BIA, which is a kind of quasi-adjudicatory part of the executive agency that had reached a conclusion about an ambiguity that had been left open under the immigration laws. And the panel didn't say anything about Chevron deference, and reached a conclusion without invoking that particular doctrine. And then Judge Gorsuch, in what I must say is like somewhat out of character, he has not really done this in many other contexts, wrote a very thorough and long concurrence. And a concurrence is essentially an opinion that provides one or several judges distinct views on an issue, but it isn't binding. It's essentially their own view of an issue that isn't a necessary element of the full panel's reasoning that allowed it to reach a particular conclusion. And in this concurrence, he laid out a very distinct theory about the relationship between federal agencies and executive power, and congressional and legislative power and judicial power. Essentially, this idea of separation of powers, which of the three branches' roles are important and in which way, and how they relate to each other. And in the course of that decision, he articulated a view that, number one, not only have federal agencies essentially taken on a life of their own and arrogated to themselves much more power than I think he felt like the founders had ever anticipated, and even more power than mid-century cases in the Supreme Court's understanding of administrative law had allowed, but also that the reason why agencies had essentially taken this power away from the courts and away from the legislative branch was a direct outcome or result from the expansion of this Chevron doctrine, which essentially really allows agencies to override judicial views on what the meaning of the law is, and require a kind of almost complete deference by courts to whatever an agency decides is right as a matter of policy. And so, in effect, the concurrence laid out a very clear view, I think, that Chevron, to be blunt, was a bad idea, and that it should, in due course, be reconsidered by the court, at a minimum pared back, but even perhaps completely overruled, to put the law, the administrative rules that govern how agencies do their work back to a place before Chevron ever existed, which would, by implication, breathe much more life back into the role of courts, federal courts, in reviewing the laws that Congress passes and any ambiguities that might exist within those laws.
And so this is an area in which there's some daylight with Scalia.
Absolutely. And so this is really the one place, or at least one of the core places where there's a fairly concrete distinction between the way Judge Gorsuch views the role of Chevron and agencies and the way that Justice Scalia did. In particular, Justice Scalia was the author of a recent opinion called City of Arlington versus FCC from 2013, which was a fairly divisive decision in which the Chief Alito and Kennedy dissented, and the majority in that case essentially held that with some very limited exceptions when an agency has general rulemaking authority under a statute, which exists for a vast number of the federal laws that you can find in this country. Its policy decisions that are reached through a kind of formal rulemaking are almost always entirely entitled to Chevron deference. And it expanded the scope of Chevron deference beyond perhaps what it may have been even a decade ago into areas that really involve even agency decisions about what they can reach decisions about. So it was this kind of meta question, like, can an agency expand the scope of its jurisdiction over what it can regulate, and is it entitled to Chevron deference for that kind of a decision? And the court said yes, and there was a very spirited dissent that the chief wrote, essentially rejecting this kind of Chevron for everything approach. And I think it's fair to say that if that case had come before the court in which Justice Scalia was not on the court and Judge Gorsuch was, you might have seen a different result, perhaps. And it's I think one of these questions that is definitely going to be different now that Justice Scalia is not on the court, and if Judge Gorsuch is in fact elevated.
So in practical terms, for real people.
Can you hang on just a second for the microphone? Sorry. Thank you. Here you go.
So in practical terms, for real people, say workers depending on an NLRB decision to uphold their back pay, what would a Gorsuch Chevron view mean?
Yeah, I mean, the strong form in his view is that agency regulations, I think, would not be entitled to a presumption of validity. So an NLRB decision that attempts to step in and protect workers on something that Congress itself hadn't completely made itself clear on will only be enforceable to the extent that it was consistent with what Congress might have intended under the law, and only valid to the extent that it had the power to persuade, that it was on its face a persuasive interpretation of a particular legal question, instead of having this kind of veneer of presumptive validity that Chevron, I think, delegates to agency rulemakings. One thing just to say about this particular question is that, it isn't, there's a way in which Chevron can insulate bad policy making from agencies as well. And so at some level, this question is a little bit whose ox is being gored. And if Chevron didn't exist, well, then maybe some truly poor policy decisions from agencies also would not be able to carry the force of this kind of presumptive validity. But, to the extent that we think that federal agencies are more able to reach these policy decisions more quickly than Congress might, and are able to put a lot of thought and expertise into decisions, and that work should be respected by courts. I think a view that Chevron is simply unavailable to agency regulations would really open up these regulatory efforts they would much more of a skeptical eye from courts, which would ease the dismantling of the administrative state to the extent that that's what judges in multiple circuits would like to see.
Could I just add, I think that the Chevron is a really important distinction between how a Justice Gorsuch would be different than a Justice Scalia. But I also want to point out, I don't know that everybody's looking at it this way. I think that sometimes we think about this judge would be replacing Justice Scalia. So, I think Amy asked the question, like, is the real fight the next one for somebody replacing Justice Kennedy, Justice Ginsburg? I think a lot of people, a lot of us, a lot of senators look at a 4-4 court right now, and then they think in that sort of those four corners, what would a Justice Gorsuch look like, and how would he affect the court? And then I think some senators, if they're not thinking about it, should be thinking about it. What would a Justice Garland have done? Again, we're not just having this as a vacuum of a vacancy. There was a nominee pending for 9 months who should have at least gotten a hearing and a vote, and if he had, I'm sure would have been confirmed. And so I think that there's a lot of different ways to think about how the court shifts and where it's shifting from, that I don't know that Justice Scalia is necessarily the right starting point, or certainly not the only one.
Ken?
Kenneth Jost, Supreme Court Yearbook. Mr. Kang said, if I got the quote right, if he, Gorsuch, is not being forthcoming, I think he's going to have a very hard time being confirmed. And I wonder if Mr. Wessler and Ms. Melling can address the question, what risks do you see from his record and his writings to Judge Gorsuch's confirmation if he is, on one hand, forthcoming or not forthcoming?
So I'm going to sort of plead ACLU just for a second, which is we don't take a position on nominees, so we comment instead on what we think are civil liberties questions. I certainly think I agree with Matt that he has been careful as you look at his writings, and I also think there are many cases that would be more controversial where they don't come to the 10th Circuit. Like the 10th Circuit isn't the first circuit everybody picks if you're picking around the country traditionally, just because it has traditionally been more conservative on some issues. I think he'll get robust questioning on abortion and Trump's views, and I think the senators would care. I think his questions right now, he may duck it, but I think questions about how he thinks about facts, I think about what he thinks the court's role are, those are broader questions, what the access is. Those are broader questions that may influence the court and where they may be able to get more information than to make it specific to issues, if that makes sense.
Yeah, I mean, I don't know that I have a lot to add on this particular question. I think that the more kind of generically broad questions that are posed to him that allow him to offer a kind of view about what the law is designed to do strikes me as a useful way to try to understand what he thinks, again, his role is and what the court's role is. I mean, I certainly think that if he were to take a position on how he views, the scope and meaning of the Federal Arbitration Act or the effect of arbitration clauses, there might be some potential risk he runs in coming onto the court at a time when he's, the next big arbitration case is going to be heard at the very beginning of next term. But it isn't to say that case implicates a kind of broader question about whether you think the court should be open and available to people who've been aggrieved, or whether you think that there's a kind of threshold door closing effect that should really winnow out claims at a very early stage. And those questions, I think, can help the public understand better how he views the judicial system and the role of the judiciary without necessarily getting him into a position where, he's actually taking a position that could implicate a case that will, is either coming down the pike or has already been agreed to go up, within the next, term and a half.
Next question, also in the front row. Right here, the gentleman in the blue shirt, please. Sorry. We have time, I promise.
Hi, I'm Jim Flug, and known to some of you as working on this type of thing in all three branches of the government. First of all, a procedural question. Does anybody on the panel have an objection to ACS having notwithstanding our deep dedication to freedom of speech, having a tradition that we bar the use of the word conservative for people like Scalia and Alito and Thomas? You don't have to answer that right now. More substantively, for those of you who have read and listened to all of the Southern literature on the nominee, do you think he will try consciously to take the approach that certainly Chris is familiar with, that Chief Justice Roberts took for his confirmation process, which is to come across as a very willing to listen, reaching out for the right answer, justice who is most concerned about what his legacy will be and not the politics of any particular decision. And if he does take that route, will it be for real? And do you think in this Senate will do the trick?
Well, I think that, and this goes back to Mr. Joe's question, I think at the end of the day, nominees want to say as little as possible to still get confirmed, right? Every time you opine on something, it's a potential for you to gain a senator's support. It's also potential for you to lose a senator's support. And so I think that, that said, I think the days of being a Supreme Court nominee and saying, I'm going to call balls and strikes and leave it at that are over. And I think that Senator Schumer has made clear that from his perspective, he sees a lot of the same traits in his courtesy meeting with Judge Gorsuch that he saw with now Chief Justice Roberts. And so I think that there's going to be a lot more pushing back for more substance, more answers. And I will also say that as Luis and Matt have gone through Judge Gorsuch's record here today, all of his opinions are really, more than fair game to ask him about, to have him answer and walk through, how did you get to this opinion? This is your opinion. How did you get to it, or opinion you joined? And what do you think that means for the broader principles? I think those are absolutely fair questions. And certainly if he doesn't even answer those, I think that a lot of Democratic senators are going to have a very hard time sort of seeing him as the independent justice that they think that the court deserves.
In the back.
This kind of goes to procedure as well. In these courtesy meetings with the members, I think it's one tactic that's been suggested is to ask how they would have ruled in cases that have already been decided. I guess maybe Chris, specifically for you, have you seen members do that in the courtesy meetings for Justices Sotomayor and Kagan? And if so, is that effective? Or does that just sort of invite the response like that's already settled law, that's precedent, that's neither here nor there for me? And then secondly, on a more substantive issue, given the judge's record on issues related to separation of powers, where is he, on immigration issues and the executive's authority, plenary authority over immigration? I don't know if anyone has been able to look at that, and if you can answer that as well.
So I can answer the first question and sort of defer to the substantive experts perhaps for the second. Senators do try to ask sort of, how would you have handled this case or this opinion? And the answer that most nominees give is that they can't answer that because they don't have sort of the briefs and the facts and the full argument. And on the one hand, that's a dodge. On the other hand, it's actually not a bad answer, sort of as you think about how you want judges to approach cases. You want them to be fully briefed and understand the specific facts and be able to ask questions during oral argument. And so I don't know that asking about specific cases gets you anywhere, but I do think there are opportunities to either ask about opinions that the judge himself has written and sort of expanding on those principles or legal theories, or to ask, as Luis and Matt have suggested, sort of broader questions so that they can't suggest that that particular issue would come before him and therefore maybe be able to elicit or expect a more fulsome answer.
Maybe just to the answer, or at least suggest a response to the substantive question. I don't know that there's a ton out there. I do think that again, this idea that Judge Gorsuch has been as percolating and came out in this Gutierrez's decision suggests that he views the judiciary as playing a very strong role in reviewing executive action. I mean, it's important to remember federal agencies are housed within the executive. I mean, there are some who believe that it's this kind of fourth branch of government, and in some ways that's true. But technically speaking, they are executive agencies, right? So to the extent that an animating principle here is a view that these executive agencies shouldn't have carte blanche to dictate to courts how they reach a certain result, might suggest, in the abstract, a stronger view of the court's ability to review and oversee executive conduct and action. That case, it's worth noting, did come up in the context of an immigration case in which the Board of Immigration Appeals was in fact attempting to override a pre-existing judicial decision, and he was quite clear that he thought that was entirely inappropriate. So, you don't want to get necessarily you want to try to draw too much out of that, but that is that context in that Gutierrez decision.
Okay, we've got a question all the way in the back.
Can you hear me? Hi, thank you. Is there anything in Gorsuch's record that could indicate how he might decide on some of the race-sensitive decisions, such as some of the affirmative action cases that may be coming up the circuit before him, primarily out of Harvard and North Carolina is one. And the other question I had is probably more for Louise. Is there anything based on your examination of his 10th Circuit record in the Hobby Lobby case that might signal how he might come down on a 6th Circuit case that may be coming up regarding how RFRA, Religious Freedom Restoration Act, may be used to challenge the EEOC's enforcement of Title VII?
Will you remind me the Sixth Circuit? Which Sixth Circuit decision are you thinking of? Oh, yeah. It's 7th, isn't it? So what's clear from his decision is that he is, as was the court in Hobby Lobby, very, very deferential to the assertions of sincerity and to the substantial burden involved in the case. So I would be quite surprised if he didn't reason similarly in that respect in the case. So the case involves a funeral home that fires a woman who's transgender, as I recall, and fires the woman because she won't adhere to they want to treat her, the funeral home wants to treat her as a man and have her dress consistent with the men's dress code. And she wants to dress, she says, I'm a woman, I need to be dressing consistent with the women's code, and she gets fired for this. And the lower court rules for the funeral home, invoking RFRA, and says that there was a least restrictive means, and the funeral home could have had a neutral dress policy. And correct me if I'm misremembering in any way. So first step is there a substantial burden? I would be very surprised if Judge Gorsuch ruled in any manner other than to say there's a substantial burden there. Compelling state interest. He has a decision addressing transgender rights, I think it's like from 2009, where that makes me think he might say compelling state interest. And we can talk about that case. If it's an unpublished decision, and it's that one, I think, and it's not signed. And then what he does with least restrictive. In the Hobby Lobby, what he went out of his way to say was, he looks to a case called Ocentro and says, you have to show that the government has a compelling state interest in making this company do it. And so to me, that interpretation misunderstands anti-discrimination rules. That the idea of an anti-discrimination rule is that you have to have it sort of uniform. Otherwise, the promise of equality isn't real. The promise of equality isn't real if I think you've sort of invited me in, and when I go to this shop, you say no, and I go to your shop and you say yes, but you've said no to me, and I thought all of a sudden the rules changed, like to welcome me into society. I no longer was going to experience a second-class status. So I would be cautious in terms of thinking that the employee would prevail if it were before Judge Gorsuch. But I don't. That's all. That's one decision, right? And how he analyzes the compelling state interest and the least restrictive means. As to the affirmative action cases, I feel sort of embarrassed to say I personally don't know, so I have my hands full with like my 5 topics. There's somebody else at the ACLU who could answer that question for you.
This is your phone a friend moment. I don't think he has any, because I think we would all be talking about them if it were, one way or the other.
He certainly has. I've read that he is somebody. This isn't exactly responsive to you, but that he's a person who has certainly questioned the McDonnell-Douglas test and raised other questions about how traditional employment discrimination cases should run. But I don't know enough to sort of tease out what that means.
Yes.
Assuming the Senate confirms somebody after the recess, what are the top candidates for oral arguments that would be scheduled for re-argument?
Go ahead.
You probably actually.
I think
thought about this
we
a
may
little
have
bit.
heard one of them this week.
Yeah.
In a case involving a cross-border shooting with Mexico.
Yeah, there was this case that was argued on Tuesday. Just this week. Feels like it was a year ago. And it is this cross-border shooting case called Hernandez, and it seems like a distinct possibility that case could get set for re-argument next term. It's always hard to know, but it's entirely possible that it could split 4-4, and it's a little complicated because there's 3 separate questions, and so what happens if only one of those questions splits 4-4? It's a bit of a messy, or what is it? What's the term? Sticky wicket, I guess. So, but that's at least right on the fresh part of what just happened. There are a couple of other cases the court has been holding for a while, and it just set them down for the end of the term. I think
they're in March.
They're in March, so it's not actually to the totally end of the term. And he won't be on.
There will not be a 9th justice by then.
And so there was some speculation that they were being held in part because perhaps Justice Scalia, when he died, he was one of the 4 who had voted to grant the case in the first place, and so they were waiting to see. And if it seems like those are split, they might be potential candidates for re-argument as well.
They were both sides in which one was called Murr, M-U-R-R, versus Wisconsin. It's a property rights case. The other one was Microsoft versus Baker, involving class actions. And they're both cases in which the conservative position lost in the lower courts, and the Supreme Court had agreed to hear them before Justice Scalia died. Louise may not want to talk about Gloucester County versus GG, the transgender bathroom case, which has been scheduled for March as well. So there, we'll not have a 9th justice by then.
I might leave it. There will not be a 9th justice by then.
Fair enough. Okay. You 1 and then 2, please. Yes.
Joe Brooks, here on my own. Have there been any senators who've indicated that they would not be willing to vote for a Supreme Court justice until the number of days had passed that Merrick Garland was not allowed to have his name put forth? And if this nomination doesn't go forward, Do we expect that Donald Trump would stick a finger in everyone's eye by nominating somebody more conservative, or could he be moved to a more moderate candidate?
Those are both very good questions. I don't think anybody, it's sort of maybe too cute by half to suggest like after 293 days, we'll let Judge Gorsuch sort of be seated. I think that there are some senators, Senator Jeff Merkley from Oregon being the most outspoken, who it seems to me he's not going to vote to confirm anybody unless their name is Merrick Garland. So there's sort of people like that, and there are sort of coming out of the box. There have been 8 senators, Democratic senators, who have announced their opposition. I don't think all of them are in that camp of nobody but Merrick Garland, but I do think that that is sort of where folks are in terms of how they're going to pivot and address Judge Garland's nomination and sort of how obscenely it was treated. What was your second question? Oh, right. If Gorsuch, so I think that so what we didn't get into is if 41 or more Democratic senators filibuster Judge Gorsuch's nomination, then Republican senators will have, the question will be to them whether or not a majority of them are willing to change the Senate rules and allow a Supreme Court justice to be confirmed by a simple majority threshold. So they can lose just a couple Republican senators and still have that rules change or nuclear option, as you will. And I'm not sure if they will. I don't know if they're going to have enough votes because there's some institutionalists in the Senate. I think that there are going to be enough concerns raised about Judge Gorsuch's nomination and his record that I think it may give people some pause about whether or not it makes sense to change the rules to seat him on the court. In that regard, I will say I think it's very different than the situation in 2013 when Democrats, you'll be surprised to know, I think, had no choice but to change the rules. And the reason I say that is because the D.C. Circuit is authorized to have 11 judges, and Senate Republicans decided that, coincidentally perhaps, 8 is enough. And it was split 4-4 in terms of judges appointed by Democratic presidents or Republican presidents. And for that reason alone, they refused to allow any of President Obama's nominees to the D.C. Circuit to be confirmed. And they were very upfront. It has nothing to do with their record, has nothing to do with how they would serve as a judge. The very reason that there were 3 vacancies and it was split 4-4, they thought that was enough because they didn't want to lose the possibility of an advantage when it came to en banc hearings in the D.C. Circuit. That is very different than what we see today. Today, a lot of this debate, again, there's some people like Senator Merkley who have this view, I'm not going to seat anybody. Most of the people are saying this nominee is too extreme, this nominee is too out of the mainstream, and therefore I'm going to filibuster. And so I think Republicans will have it's going to be a hard question to them. I'll be surprised if they change the rules, but if they do, obviously then Judge Gorsuch would be confirmed with the majority of the Senate voting to confirm him. If they don't, then really the question is to President Trump. Does he want to meaningfully seek the advice of Senate Democrats and the constitutional responsibility of advice and consent, or does he poke them in the eye? And sort of the course of the last month, I think probably gives you some evidence that he could go either way. I would say that there's been a lot of eye poking in the last month, but you also look at what happened in the Department of Labor and when Mr. Putzer's nomination was withdrawn, the president nominated Alex Acosta. And now there's still a lot to be determined from his record, but I think that the initial review and reaction certainly is not as negative to Mr. Acosta's potential leadership over the Department of Labor as it was for Mr. Putzer.
I promised the gentleman in the blue plaid shirt that he could be the...
So Matt in particular talked a lot about how Judge Gorsuch's opinions are sort of enigmatic, and it's tough to sort of glean a larger judicial philosophy from them. And I know this question is impossible, so this is more of like what your gut reaction is. But did you get the sense that that's sort of his judicial style, and on the Supreme Court, that's what you would expect to see, sort of a judge writing these sort of minimalist opinions that just address the case before him? Or is it, you think he was sort of eyeing Supreme Court down the road and was being very careful in writing the opinions to sort of not make himself a target or harm his chances.
I mean, with the caveat that I have no idea really, because I just, I don't know him, but I do think that there's a little bit of this kind of dissonance between the kind of mine run decisions that you see and his concurrence in the Gutierrez case, which is it really marks, it stakes out some ground that is controversial. And he wrote that concurrence with flair, with style. I think when people are trying to compare writing styles, it has this kind of Gestalt Scalia feel to it a little bit. It's long. You don't normally see concurrences that run twice or three times as long as a panel opinion. This was that. He really staked out a strong form view of a particular doctrinal question that is a very hotly contested one. And so I think that strikes me as perhaps more of a clue once, that he might approach these cases and his written work product with a real strong form personality of his own views than perhaps necessarily a much more kind of nuts and bolts way.
His dissents from some of the en banc, the refusals of the court to review decisions en banc in the religion field, both in terms of things like American atheists as well as in Zubik, and then his own, not Zubik, but the parallel down below in the 10th Circuit, Little Sisters, and also his concurrence in the Hobby Lobby decision. Those are not shrinking violet decisions. Those are strong. Those are robust. Those are full-throttled defenses of a particular way of understanding both the Establishment Clause as well as free exercise.
All right, you have the last word, Louise. Please join me in thanking our terrific panel.